Hello and welcome to another blockbuster episode on XRP Zone. Today, we brought you very interesting and important news. If you are an XRP investor or plan to invest in it, the XRP-Attorney has predicted the explosion of XRP, and that is going to spread fire across the world of cryptocurrency, so make sure you watch this video until the end with us. Let's get started. According to finance feeds, this would mean XRP is a digital asset and subject to regulation by the CFTC and not the SEC. Large parts of the SEC lawsuit would then become moot, according to attorney Thian Vu Hogan. Attorney Thian Vu Hogan, the founding and managing partner of Hogan & Hogan, has reviewed the proposed legislation introduced by U.S. Representative Don Beyer in late July. The Digital Asset Market Structure and Investor Protection Act aims to protect consumers and promote innovation by incorporating digital assets into existing financial regulatory structures. A digital asset which provides the holder of the digital asset with any of the following rights. And then, if you see Roman numeral 1 to 4, it basically is defining you what you traditionally think of as a security: rights to profits, interest or dividends, voting rights. This is where attorney Hogan finds the way out for Ripple XRP. The definition is basically what former director Hinman was talking about in his speech. The law defines a security as a digital asset where the platform is not fully built out and for which the money from the sales fund the development of the proposed service, goods, or platform of the issuer, she said in the video. And that's it. If the digital asset does not act like a traditional security, like a share of a company, and the money from the sale is not used to build the digital platform, then it's not a digital security and not subject to regulation by the SEC. The lawyer then went step by step in her analysis of XRP as a potential security. The first part of the test is whether XRP has any of the hallmarks of a traditional security. If you own XRP, do you have an equity interest in voting rights in Ripple? No, absolutely not. That's an easy one. As to the second part of the test, was the service, good, or platform was wholly operational at the time of the sale, or is the money from this sale used to fund the development of the platform? This part of the test is a little more complicated, but certainly the XRP ledger, etc., which is the base of the Ripple platform, is and has been wholly operational for some time. You can make an argument that certain of the newer products that Ripple has deployed in the last couple of years are new, and that XRP sales money was used to develop them, but Ripple's business is the software that surrounds the platform and definitely does not seem like the kind of the thing the legislation envisions as a digital security. If this legislation passes, XRP is unlikely to fall under the definition of a digital security asset, so not subject to regulation by the SEC, Ms. Hogan concluded. Given that the bill could be enacted while the SEC versus Ripple is going on, the question is to whether the law applies retroactively arises. Well, the United States Supreme Court gave us an answer in 1994 in the case of Landgraf versus USI Film Products. The Landgraf case was a sexual harassment case, but it involved application of a change of law during the pendency of litigation and provides a framework for our XRP analysis. Additionally, the US Constitution says in Article 1 that no state shall pass any ex post facto law or law impairing the obligation of contracts. Ex post facto applies in only two situations. Number 1, to criminal statutes, and number 2, where the after-the-fact law imposes greater civil penalties on the subject, according to the lawyer. So here, applying the new law to Ripple's situation, we passed those two tests because the law is not criminal and none of the defendants are charged with a crime, and also because in this specific case, the law would not create greater civil penalties. In fact, it will probably lead to the end of the lawsuit. As to legislator intent, the Landgraf case points to the effect that the statute will have. If the law increases the parties' liability for past conduct, it's not applied retroactively. This specific proposed bill increases liability, especially for exchanges, but not as to whether XRP is a security or not. So in that case, the new law helps Ripple and therefore it'll be very likely to be applied retroactively. So our conclusion from applying this pending law to the SEC versus Ripple case is that the courts will likely apply the law retroactively, and under this new definition, at least a large part. Certainly, the last few years of Ripple's business practices, XRP would be defined as just a digital asset and not a digital asset security, and therefore not subject to SEC regulation. This would mean that XRP is a digital asset and subject to the regulation by the Commodity Trading Commission and not the SEC, and large part of the SEC lawsuit would become moot, Attorney Hogan concluded. All this news coming regarding XRP makes us predict the fact in front of us that is shouting that the attorney of the SEC has undoubtedly given a signal that the XRP is going to explode. XRP is going wild around the world, even when it's surrounded by the SEC lawsuit trying to bring it down and sue it, because they know that once XRP takes the lead, the local banking systems will vanish just in a blink of an eye, because XRP offers way more than they have in years. In fact, the new modern technological world demands fast means of transactions that the XRP is there to offer. Not even this. According to Daily Hodl, lawyers representing Ripple have responded to the US Securities and Exchange Commission after it opposed their efforts to determine whether SEC employees were allowed to purchase XRP while simultaneously conducting an investigation of Ripple for securities fraud. The SEC alleges that Ripple used XRP as an unregistered security and that the crypto is still in violation. In legal filings revealed by lawyer and XRP supporter James K. Phelan, Ripple asserts its right to anonymized data as part of the discovery process. The SEC's claim that the motion constitutes an intrusion of privacy for SEC employees ignores that Ripple does not seek any particularized information relating to SEC employees, but completely anonymized information of a narrow scope. Last week, the SEC opposed the motion to compel the production of confidential details of trading by individual SEC employees whose personal affairs are not an issue in this case. But Ripple's latest court filings contends that the SEC permitted XRP purchases and sales by its own employees, directly undermines the SEC's claims that since 2013, Ripple acted recklessly because it was so obvious that XRP was a security that they must have been aware of it. SEC counsel orally indicated that SEC employees could not trade XRP after the formal order of investigation was issued as to Ripple on March 9, 2019. The SEC now refuses to confirm its oral statement in writing and refuses to state how many SEC employees requested and/or received permission to trade XRP after January 2018, but before March 9, 2019. The SEC's legal team has indicated the regulator eventually did prohibit its employees from trading XRP, but not until March 2019, when it issued a formal order of investigation on Ripple. Ripple's latest filing implies that the SEC's allegations may contradict the notion that their own employees were allowed to trade XRP as late as March 2019. There's an obvious tension between the SEC's broad theory in this case, that every offer, sale, and distribution of XRP by defendants since 2013 constituted an investment contract, and that the individual defendants recklessly disregarded the law, and the fact, which we seek to confirm, that the SEC's own employees were permitted to trade in XRP as late as March 9th, 2019, and possibly thereafter. There are extremely positive parts in terms of XRP and its price. Its popularity has already taken the world by storm and spread like wildfire, but we're to see more of it when the case settles down. With that being said, the world of cryptocurrencies is extremely strange and unpredictable. 1 minute it'll be up and another minute it'll be down, so just don't take this video as investment advice. It's only for educational purposes. Where and when to invest is solely based on you and your research and your knowledge about a valid cryptocurrency. That was all from our side. Thank you so much for watching this video, and make sure to like this video if you haven't already and subscribe to the channel for more content regarding XRP.